prime suspect.
Right.
However, you'd also seen the Twitter messages between Stephen Walker and Sally Draft, correct?
That is correct.
So you knew they were dating.
Yes.
You knew that Sally Draft lived with John Draft,
Yes.
and that she may want to visit her boyfriend.
Yes.
Objection, speculation.
Repeat the question.
That she may want to visit her boyfriend.
What's your objection?
Speculation. You can't know what she wanted to do.
Sustained.
You knew there was a possibility she would visit her boyfriend.
There is a possibility, yes.
And this became the piece of evidence that made John Draft a prime suspect.
Yes.
Now, Mr. Stockard, you're not a police officer, correct?
That is correct.
In fact, you work for the district attorney's office.
That is correct.
From the scene, you mentioned that you had called Mr. Draft.
Yes.
However, you didn't mention the fact that he had began speaking nonsense.
Objection, hearsay.
Overruled.
You didn't mention the fact that he was speaking nonsense.
No, I did not mention.
Things that didn't make any sense.
Right.
Now, you said you worked with the sheriff's department in this investigation.
Yes.
However, you're not aware if the sheriff's department conducted any gunshot residue testing.
Well, I conducted the gunshot residue tests.
Is your testimony that you conducted gunshot residue testing?
Well, I noticed that when I looked at the body that there wasn't gunshot residue, but we also did the tests.
Wish to approach opposing counsel. A copy of the witness's former testimony. Let the record reflect that I'm approaching the witness with the same document. Investigator Stockard, do you recognize that document?
Explaining which portion of the document.
I will be referring to the document in its entirety.
1 second, counsel. Any page starting on counsel?
Again, Your Honor, we refer to the document in its entirety.
Okay.
Now, Investigator Stockard, you recognize that document, correct?
Yes.
That is a transcript of your testimony in a hearing regarding the same matter.
Yes, it is.
At that testimony, you were sworn to tell the whole truth and nothing but the truth.
Yes.
And at that hearing, you were represented by counsel.
No.
You had counsel directing your examination, correct?
Yes.
You were told to include all information relevant and critical to the matter at hand.
Yes.
Can you tell me, or nowhere in that document?
Objection, improper impeachment. This is impeachment on a collateral matter, and there is no inconsistency between his prior testimony and his testimony today.
Well, we're getting there, aren't we?
Yes, Your Honor.
Overruled.
Nowhere in that document, during your entire testimony, did you mention performing gunshot residue testing.
Not in the document. That's right.
Permission to approach.
Granted.
Again, you said you were working with the sheriff's department, and you're not aware of any fingerprint analysis with the sheriff's department.
Right.
You're not aware of any DNA testing
No.
or any results that may have come from any test of the level.
No.
You're not aware if the sheriff's department interviewed Sally Draft.
No.
Sally Draft being the last person to see Stephen Walker alive.
Correct.
Objection, speculation, as there was the last person to see him alive.
Your Honor, if this wasn't deep speculation, the witness would not be able to answer in the affirmative. He would respond with the fact that he does not know.
I think he is speculating, so objection sustained.
Move to strike.
Stricken.
Court's indulgence. Permission to approach, or let the record reflect I'm approaching opposing counsel with what has been marked for identification purposes as defense exhibit 10. Let the record reflect that I'm approaching the witness with the same document. Stockton, you recognize the document I just handed you, correct?
Yes, I do.
That is a letter that you found near the body of Stephen Walker.
That's correct.
After reviewing this letter, what, if anything, did you do to follow up on it?
We did not follow up on this.
This time, or is it a fair and accurate copy of the letter that you found at the scene?
Yes.
This time, defense offers Exhibit 10 to evidence.
Objection based on hearsay and 403. Would you like to hear from the state first?
Sure.
As to hearsay, this is an out-of-court statement being offered for the truth of the matter asserted, or at least for no purpose recognized as a non-hearsay purpose. And as to Rule 403, the probative value of this unsigned statement by some mystery party is extremely low, and the danger of unfair prejudice substantially outweighs that probative value, because it can inflame the passions of the jury by showing some sort of mystery, angry people who are angry at the victim without actually tending to prove that any such people existed. There's no evidence that Mr. Walker didn't write this himself.
Your Honor, with respect to the hearsay objection, this would be not hearsay because it's not being offered for the truth of the matter asserted. It is being offered for the fact that it was said and found by the investigator and had a lack of effect on the investigation. With regard to the 403 argument, I would argue that, first of all, there can be no unfair prejudice to the state in this regard, because all this would do is, as opposing counsel proposes, would show the existence of some mystery, angry people. All this serves to do is create the possibility of reasonable doubt in the minds of the jury, which is indeed the purpose of the defense here today.
Objection over what do you think has public value?
Permission to publish to the jury?
Permission granted.
Investigator Stockard, after seeing this letter, you did not look into whether Stephen Walker was in debt?
No, I did.
You didn't look into who he had been hanging out with?
No.
You didn't look into who his enemies were?
No.
No further questions.
Mr. Stockard, you mentioned a gunshot residue test.
Mm-hmm.
Why didn't you mention that in the last hearing?